Hello and welcome to Property Appraisal Part 1. Property Appraisal Part 1 will introduce property appraisals, the reasons for filing a protest with the Appraisal Review Board, important deadlines, scheduling information, the 3 steps of the appeal process, and important reminders. All property owners are responsible for paying property taxes every year. Property taxes are based on your home's value. Texas law establishes the process followed by local officials in determining the value for your property and ensuring that values are equal and uniform. The property tax process for each tax year includes a series of steps. Appraisal districts are required to assess your property based on the home's market value on January 1st. Market value is the actual value of your property if it were placed on the open market. In other words, market value is determined by the amount buyers would be willing to pay to purchase the home. From January 1st to April 30th, appraisal districts complete appraisals and process applications for exemptions. Between April and May, the appraisal district will send you a notice of your home's value. Finally, from May to July, the Appraisal Review Board hears protests from property owners. So what is an appraisal? An appraisal is a professional opinion of a home's value. Appraisals are expected to be unbiased and objective. Each county appraisal district determines the value of all taxable property within the county boundaries, including homes. So who hears the protest? If you disagree with the appraised value of your home, you can file a protest with the appraisal district. The Appraisal Review Board is an independent board of citizens that hears and determines protests regarding property appraisals or other concerns. If you decide to protest your property appraisal, you should file Form 50-132, Notice of Protest with the ARB. Here is an example of the Notice of Protest form. You may follow the appeal procedures for several concerns. The 2 most common reasons are the proposed value of your property is too high, or your property is unequally valued compared with other property in the appraisal district. Your property value should be close to or equal to the property value of similar homes in your area. You could verify this by asking the appraisal district for appraisal records on similar properties in your area. If there is a big difference in the values, the appraisal district might not be treating your property equally to other similar properties. A protest must be filed by May 15th or no later than 30 days from the date of your notice of appraised value, whichever is later. For properties that do not receive a notice of appraised value, the protest deadline is May 15th. It is very important to file the protest on time. You might be able to file a late protest. The ARB makes this decision. For example, according to the Texas Comptroller, if your protest is late because the chief appraiser or ARB failed to mail a required notice of appraised value, you may file your protest anytime before the taxes become delinquent. You will receive written notice of the date, time, and place of your formal hearing with the ARB at least 15 days before your hearing date. You are entitled to 1 hearing postponement without showing cause. You must request the postponement before the hearing date in writing. Additional postponements may also be available. Please consider viewing our FAQ page for more information on scheduling and postponements. Now we will discuss the 3 steps of the appeal process. Let's start with step 1, the informal hearing. All homeowners are required to informally review their property appraisal with a member of the district staff before going to a formal hearing. After informally reviewing the property appraisal, the appraiser can choose one of 2 options. They can change the appraised value based on a review of all information, or they can make no change to the original appraisal. After your informal property review and receiving the appraiser's action on the review, homeowners may choose one of 2 options. You can agree with the decision the appraiser made to the appraised value and sign a settlement and agreement waiver. This agreement is final and binding and will officially close the protest for that tax year. Or you can disagree with the decision the appraiser made and attend a hearing that will be scheduled at a later date with the Appraisal Review Board. So now you may be wondering, how should I prepare for an informal hearing? And the best thing to do is bring evidence. Presenting evidence to argue why your property value is too high or incorrect will be the best way to receive a favorable settlement offer. Please consider watching Property Appraisal Part 2 for more information. Step 2 is the hearing in front of the ARB. If you disagree with the informal hearing results, you have the right to a formal hearing in front of the Appraisal Review Board. As a reminder, the Appraisal Review Board is a group of citizens authorized to resolve disputes between taxpayers and the appraisal district. There are 3 ways to appear in front of the ARB board: either in person, through submitting an affidavit, or through a telephone conference call. Option 1, in person. You may appear in person, or you may authorize someone else in writing to appear on your behalf. The person you select should be able to discuss the property from personal knowledge and should file Form 5162 as soon as possible. The form must be on file prior to your scheduled ARB hearing. You may also designate an attorney, mortgage lender, or employee to appear. If you choose to do this, no form is needed. To authorize someone who is paid for representing you, you must file a special appointment of agent form. This form is available on the Texas Comptroller site or in the list of appraisal materials on our site. Option 2, you can submit an affidavit. You may file your evidence in the form of an affidavit. An affidavit is a sworn statement put in writing. Your affidavit and evidence for the hearing must be submitted to the ARB either on paper or on a small portable electronic device, such as a CD, a USB flash drive, or a thumb drive. The affidavit and all supporting documents must be received by the ARB before the scheduled hearing date. Please be sure to provide ample mailing time and ensure it is mailed to the correct address. The affidavit must be signed before a notary public stating that you swear or affirm that the information it contains is true and correct. Please remember to identify in the affidavit the property owner's name, address, account number, property description, opinion of value, and the date and time of the hearing. You may use Form 5283 for your affidavit. The form is on the Texas Comptroller site and also on our site. The third option to appear in front of the ARB is through a telephone conference call. Evidence submitted for telephone hearings must be in the form of an affidavit. Please remember to identify in your affidavit the property owner's name, address, account number, property description, opinion of value, and the date and time of the hearing. Now we will discuss what you can expect when you arrive at the formal hearing with the ARB. First, there will be a welcome. The Appraisal Review Board will read an introductory statement. the ARB will remind participants of the content of the hearing, procedures, time limits for the hearing, and other relevant matters. Then you will get to decide if you want to present your evidence before or after the appraisal district. Let's say you decide to present your evidence first. Then you will present your evidence, including documents, testimony, and witnesses. The appraisal district will then have the opportunity to cross-examine you and any of your witnesses. After this, the appraisal district will have the opportunity to present their evidence, which can include documents, testimony, or witnesses. You will then have the opportunity to cross-examine the appraisal district and its witnesses. After this, you will have the opportunity to provide a rebuttal. A rebuttal is a form of evidence that is presented to refute evidence that has been presented by an adverse party. The appraisal district will then have the opportunity to offer their rebuttal. After the rebuttals, you will then make your closing argument. A closing argument is a concluding statement reiterating the important arguments and facts of the hearing. After you make your closing argument, the appraisal district will have the opportunity to make its closing argument. After this, the ARB panel will close the hearing. The ARB panel will discuss the evidence presented by you and the appraisal district. And after deliberation, the ARB will announce its decision. If you are dissatisfied with the decision of the ARB, you have three possible solutions. One solution is a binding arbitration. Arbitration is a method of resolving disputes outside of court. Parties present their disputes to an arbitrator who reviews the evidence, listens to parties, and then makes a decision. In binding arbitration, the arbitrator's decision is final. It is usually not reviewed or overturned except in very limited circumstances. You must file a request for binding arbitration with the county appraisal district no later than the 45th day after you receive notice of the ARB's decision. Another option is to go through the State Office of Administrative Hearings. The State Office of Administrative Hearings, also called SOAH, resolves disputes between Texas agencies and private citizens, either through an administrative hearing or mediation. The office is separate and independent from the agencies involved in the disputes. The administrative law judge who presides over the disputes are expected to be neutral. The objectives of the State Office of Administrative Hearings include conducting fair and objective administrative hearings and providing fair, timely, and efficient decisions and proposals for decisions. You must file an appeal with the County Appraisal District no later than the 30th day after you receive notice of the ARB's decision. Finally, you have the option to appeal to the district court. The district court has the authority to hear your case after receiving a ruling from the ARB. It is recommended that you consult with an attorney if you decide to appeal to the district court. You must file a petition with the district court within 60 days of the date you receive the ARB's decision. It is also important to note that the appeals to the district court, binding arbitration, or going through the State Office of Administrative Hearings all require payment of certain fees or deposits. Finally, there are things to keep in mind while you are appealing your property appraisal. You must pay the amount of taxes due on the portion of the taxable value that is not in dispute. For example, if your taxes are $10,000 and you are disputing $5,000, you are still required to pay the undisputed $5,000 by the deadline. This concludes Property Appraisal Part 1. For more information, please consider watching the additional appraisal videos on our site. Thank you.